10 questions about setting up business in Ukraine. My name is Alexander Melnik. I am a partner and head of corporate and M&A practice at GOLAW firm. Today I will answer 10 most common questions about entering Ukrainian market. If you have any additional questions, please feel free to comment and I will respond later on. So first question is, what is the best legal form to start business in Ukraine in 2026? An LLC or representative office. So it depends on your goals because these two forms have different purposes. In most cases, limited liability company is the best option for entering the Ukrainian market as it gives opportunity to fully conduct practically any activity in Ukraine. An LLC is a separate legal entity with limited liability for its shareholders and a well-developed corporate framework. LLC allows direct independent participation in procurement and commercial contracts, which is essential for doing business in Ukraine. It can obtain any license or permit. A representative office, on the contrary, is not a legal entity and is usually used only for coordination and preparatory activities, as the foreign parent company remains fully liable for its operation in Ukraine. It has limited possibility to obtain licenses and permits and limited possibility to participate in public procurement. So, if you are planning to conduct business, stick to LLC. If it's about market research and promotion or preparatory work, you can go with representative office. So the next question, how fast and how expensive is it to incorporate a company in Ukraine today? Incorporation of LLC in Ukraine is a relatively fast and cost-effective procedure. State registration usually takes from 1 to 2 business days if all documents in place and is free of state charges and duties. However, any foreign investor should consider additional costs for notary and translation services, which depending on situation may amount between 300 and 600 euro, and estimate time because gathering apostille documents and sending them to Ukraine may take some weeks, depending on specific jurisdiction. Ukrainian law doesn't set a minimum charter capital requirement, so companies can start with a very small amount. Next question. What taxes should foreign investor expect when doing business in Ukraine? The standard corporate income tax rate in Ukraine is 18% calculated from profit, meaning income minus expenses. Alternatively, a company may choose simplified taxation system, which is 5% income tax calculated without consideration of expenses. Value-added tax is generally charged at 20% with reduced or zero rates for specific types of transactions, including exports. Payment of dividends, interest, or royalties to non-residents are subject to a 15% withholding tax, which may be reduced if a double taxation treaty applies. Payroll taxes include 18% personal income tax plus 22% unified social contribution and 5% military tax. Tax rates and obligations may vary depending on the nature and structure of specific business or transactions. The next question is, are there any currency control or dividends repatriation restrictions in Ukraine in 2026? So Ukraine still applies wartime currency controls, so profit repatriation and cross-border debt service are rule-based, not automatic. Ukraine companies can repatriate dividends to non-residents, but only for profits accrued from 1st of January 2023 and onward, and typically within a monthly cap of 1 million euro per company, paid directly to the investor abroad through the bank. Also, if the company receives new foreign currency equity injections after May 2025, an investment limit concept may allow additional currency transfers beyond general caps in defined cases. For external loans, the National Bank of Ukraine has eased servicing rules. The new loans, which are provided after June 2023, is generally permitted to repay the principal amount and interest, subject to conditions, including maximum interest rate threshold in the National Bank's framework. However, These regulations and limitations are gradually eased, and we expect them to be lifted after the war ends. Okay, let's go to another question. What are the key anti-money laundering and UBO disclosure requirements for companies in Ukraine? So, Ukrainian companies must disclose detailed information about their ultimate beneficial owners, ownership structure, and submit to the registrar respective supporting corporate documents. This disclosure is required at the incorporation stage, annually, and whenever the changes occur. The same information is also requested by banks, lawyers, and other AML reporting entities during KYC procedures, making transparency a key compliance obligation. When opening bank account, paying dividends abroad, receiving foreign funds, or doing M&A, expect banks, notaries, and other obliged entities to require UBO evidence, ownership structure, signatory authority documents, source of funds, wealth explanation, and politically exposed person and sanction screening under AML laws risks-based approach. Okay, let's move to another question, and it's can a foreign national own and manage a Ukrainian company, and how does the work permit process work? So, foreign nationals can own a Ukrainian company and in most cases can own 100% of shares. The main practical exceptions are usually sector or asset specific. For example, agricultural land ownership is restricted for foreigners. And of course now, ownership for Russian citizens is blocked. Foreign nationals can also manage a Ukrainian company as a director with two options, either based on employment agreement or civil law agreement. In case of civil law agreement, foreign director doesn't need a work permit, but it prevents him from getting temporary residence permit on the basis of employment and long-term stay. In case of employment, a foreign director needs a Ukrainian work permit before they can officially perform management duties. A work permit is obtained by a company from State Employment Service within 15 days upon document submission. After this, a foreigner can be employed at the company and further may get a temporary residence permit based on employment. The next question is, how reliable is the Ukrainian legal system for dispute resolution and investment protection? Ukraine has implemented significant judicial reform, including a renewed Supreme Court and updated procedural codes. The court system includes commercial, administrative, and general courts. Ukraine recognizes and enforces foreign court judgments and arbitral awards and is a party to key international investments such as the New York Convention and the ICSID Convention. For cross-border contracts, arbitration is often the more predictable route. Ukraine has a well-established institution, the International Commercial Arbitration Court at the Ukrainian Chamber of Commerce. And the Supreme Court has publicly emphasized a pro-arbitration, pro-enforcement approach in recent years. In addition, foreign investors typically rely on bilateral investment treaty protections and treaty arbitration frameworks. Ukraine has a broad network of investment treaties listed by UNCTAD. Now we have a question about intellectual property. How is intellectual property protected in Ukraine, especially software and technology? Ukraine law protects the full standard set of IP rights: copyright, trademarks, patents, utility models, industrial designs, and trade secrets, with a registration-based system for most industrial rights. Software is protected automatically by copyright from the moment of creation and doesn't require registration. Registration is optional but often used to strengthen evidence in dispute and transactions. For technology, protection is typically split: copyright for code and documentation, patents and utility models for protectable technical solution, trade secrets for algorithm data, and know-how where confidentiality is maintained. Ukraine is effectively first to file for registrable rights, trademarks, patents, designs. So, filing strategy and timing matters, especially before public disclosure of market entry. Ukraine uses internationally recognized filing and protection pathways, for example, PCT for patents and Madrid for trademarks, and aligns with IP system with major international standards. Rights are typically enforced through civil claims, injunctions, damages, seizure of infringing goods, and can be supported by border measures via customs for counterfeit goods, which is particularly relevant for branded products. What are the most attractive sectors for foreign investors entering Ukraine in 2026? Well, from legal and regulatory and bankability perspective, the most attractive sectors for foreign investors entering Ukraine in 2026 are the ones that are explicitly prioritized by EU IFI programs and have clear permitting asset models and can be structured into project finance or guarantees framework. Most investable sectors in 2026 are energy and energy infrastructure, generation, grid, storage, efficiency, which is consistently prioritized by EU investment programming with strong alignment to resilience and EU market integration. Infrastructure and logistics like rail, urban transport, border crossing, ports where feasible, a core focus of EU-backed connectivity and export routes typically supported by blended finance and guarantees. Critical raw materials and strategic industry, including processing and refining, now explicitly targeted by US-Ukraine reconstruction investment agenda for first project in 2026 and also framed as strategic industry and raw materials within EU investment architecture. Agri-food and food security, including processing, storage, logistics, input supply chains, and so on. It is a top priority area for major IFIs, not just primary agriculture, also processing and resilient investment. Housing, construction, and building materials is a reconstruction-driven demand. Supported by large-scale recovery programming, construction materials and modern building solutions are increasingly framed as structured investment opportunities. And also IT and emerging technologies, including dual-use tech, explicitly listed among priority sectors under the US-Ukraine investment agenda and increasingly present in EU investment framing, typically easier to scale and less asset-heavy than heavy industry. And of course, defense and defense-adjacent manufacturing were compliant and export control. Growing focus on joint ventures, procurement cooperation and localization, often via structured partnerships rather than simple greenfield builds. Okay, and the last question is: what special legal regimes and incentives are available for strategic and high-tech businesses in Ukraine? Ukraine currently uses several targeted legal regimes for foreign investors, typically considered most bankable for strategic and high-tech projects. First is DSCT. It is for tech, IT, R&D. It is a special corporate and tax framework for eligible tech businesses with options such as 9% exit capital tax, alternative to standard CIT, and preferential employment contracting models for talents. And another is industrial parks for manufacturing, processing, including high-tech production. It packages of tax and customs incentives, notably on equipment import and subject to conditions corporate income tax relief, plus possible state co-financing for infrastructure. Also, we have a significant investment framework for large strategic projects costing 12 or more million euro. It provides state support through special investment agreement, potentially including infrastructure support and certain tax customs instruments depending on project eligibility. And the new one is Defense City, created for defense and dual-use companies. It is a dedicated regime being rolled out specifically for defense sector via a registered-based model positioned as a package of incentives and regulatory facilitations for defense manufacturing and related tech. Thank you very much. If you like this kind of content, don't forget to like, comment, and subscribe to our YouTube channel and social media. Find all the links below. Thank you. Keep safe.